All right, well, welcome everybody to our industry update this month. Thank you so much for joining us. If you're returning, thanks for coming back and joining us again. If it's your first industry update, we really appreciate you checking us out, and we hope you get a lot out of today. And let me click along here. I always like to give you a heads up as to the subject matter for our future updates. So save the dates. We're always the first Thursday of the month at 2 o'clock in the afternoon. And so next month on April 7th, we're going to have Pete Muccio back on. He is a landlord tenant attorney. So if you have rental properties or you work with clients who own rental properties, be a good idea to tune in and see what he has to say. There's been just so many changes over the last couple of years with regards to investment properties. So, and then May 5th, the Marcia Waters will be on giving us an update from the Real Estate Commission. So we're excited to hear what she's got to say. And then June 2nd, we'll have a legislative review with Liz Peets, who's the attorney, who's also the Vice President of Government Affairs for the Colorado Association of Realtors. So she's going to be telling us about all the new legislative changes that are happening in our industry. So save those dates. And then without further ado, I want to introduce our guest speaker today, so Mr. Dean Ruybal. Dean is the Regional Chief Title Officer for Heritage Title, has been in that role for 31 years and worked as a commercial title examiner for 10 years prior to that. So 41 years of experience. Sorry, he's such a newbie. We'll try to find somebody with a little more experience next time for you. He does a lot of training and education across multiple industries related to title insurance. So he's trained for LTAC, the Land Title Association of Colorado, the Colorado Bar Association, the Colorado Association of Certified Closers, and the Central Colorado Professional Surveyors Association. He's also been a guest speaker for the National Escrow Association, and he's held the designation of Certified Title Insurance Specialist by LTAC since 1997. So really excited to hear from Dean today. He's just a wealth of knowledge. And this is a subject area that as a rep, I get a lot of questions from brokers on when they're listing a property and it's held by an LLC or a trust. And there are just some different nuances there, and we want to talk about those today. So with that, I'll let Dean take things away. And Damian and I are on as well to try to field some questions. So put anything into Q&A that you want, and we'll try to get everybody's questions answered today. So with that, let me stop my share. Dean, you can share away and we'll kick things off.
All right, can you see my screen?
Yes.
All right. So we are just going to go over the different types of entities that hold title to real estate and who has the authority to bind those entities, basically, and then possibly talk about how the signature line should read, and if you have any questions about how that's set up. First one is going to be, which we see a lot of, and that's power of attorneys. So we see an attorney, in fact, is going to be executing on behalf of an individual, could be on behalf of an entity as well. We'll talk about that. But what we're looking for is the power of attorney that gives them that authority. And what we're looking for is what are the powers and limitations of their authority. More often than not, the named attorney, in fact, can attend the closing and wants to delegate their authority. We want to double check the power of attorney to see if there are any restrictions on delegating their authority. If you are using a title insurance company form of power of attorney, more often than not, there is a stop on that power of attorney that basically states that my agent may not delegate the power constituted in them by this power of attorney, despite any contrary provisions of any applicable law or regulation. So an attorney, in fact, has the power to delegate their authority unless the document that gives them that authority restricts it. So that's one of the things that we're going to be looking for. Oftentimes, we are also looking at the age of the power of attorney. Although there is no statute of limitations on how long a power of attorney is in full force and effect, depending on the age of the power of attorney, a title insurance company may require that a power of attorney affidavit be executed by the attorney in fact, stating that the power of attorney has not terminated and that their powers are still in full force and effect. Bankruptcy. Oftentimes, yeah.
Dean, before you move
Yes.
on, just because I want to make sure I sound like I'm important or that I'm adding something to this conversation, but but the power of attorney, some of the things that I always hear on questions, you mentioned about that you look at the age as far as how old is the power of attorney. And, a lot of times I see that, it has to have reference to the specific property that is being addressed or being sold. Can you address some of the stuff that you guys look at? Because what I see a lot of times is you have an estate attorney that prepares a durable power of attorney and then expects that that's going to be okay to sell the property. Broker says, oh, okay, it's an attorney telling us this is fine. Then you get up to closing, and then obviously title has all sorts of issues because of those different problems that they run into. Yeah. Would you mind addressing that a little bit so that they know what you guys are looking at and what you really need so they can try and get it ahead of time at the time of listing?
You bet. So typically, if it is a title insurance company form that's being used for the power of attorney, they are property specific. They're specific to a certain piece of property. With a Colorado statutory general power of attorney, it allows them to deal with any real property issues. So that's going to be the difference between the two. Is it property specific, or is it a general power of attorney that allows them to deal with all real property issues?
And when it just deals with all real property issues, do you guys are you okay with dealing with that general power of attorney and using it, or do you prefer to have the specific one?
No, we can accept the general power of attorney. We can't refuse a power of attorney if it delegates the proper authority.
Okay, great.
We can't force them to use our form.
Okay, perfect. Thank you.
You bet. Bankruptcy. Well, when you're filing for bankruptcy, Chapter 7 or Chapter 13, basically what you're doing is you're turning over all your assets and your liabilities over to the bankruptcy court to liquidate your assets to pay off your liabilities. One of your assets is going to be that real estate. And as soon as you file for bankruptcy, you are turning over that asset to the bankruptcy court. So now the bankruptcy trustee is the one that's in charge of any real property issues or any issues that deal with that debtor. Before we can insure when the party is in bankruptcy, either we have to get the trustee's permission to sell. If the trustee wants to be the one that's in control of the sale, then there will be a court order appointing the trustee to execute all the documents. If there is a homestead that applies, if the equity in the property doesn't exceed the homestead exemption, then more often than not, the bankruptcy trustee will abandon the property to allow the sale of the property, or issue a court order to allow the sale of the property. If it is a Chapter 13, when you're setting up a plan, oftentimes it's a 5-year plan, we as a title insurance company are looking to, one, make sure that the property has been listed as an asset, and two, that the Chapter 13 plan has been confirmed. Once a Chapter 13 plan has been confirmed, that revests the debtor in title to the property. So we don't need a court order after that, or an abandonment of the property, or the closing of the case.
And you and I were talking about this briefly, but a lot of times with property, you just don't see a lot of times that the bankruptcy court is actually involved in those. A lot of times it's, particularly when you're talking residential, it gets abandoned and moved on. Yeah.
You typically are talking about very large bankruptcies. Oftentimes it's an involuntary bankruptcy where you've had 3 creditors force the party into bankruptcy, and they want the bankruptcy trustee to oversee the process. So it's not a voluntary bankruptcy.
All right, thanks for that.
You betcha. Corporations, see a lot of those. The parties that have the authorization to bind the entity are going to be one of the corporate officers. It's typically going to be a president, vice president, secretary, or the treasurer. What we're looking for in that situation is to make sure that they filed all of the proper documentations with their Secretary of State. We're looking for articles of organization, the bylaws, and a certificate of good standing. We are going to be looking for a corporate resolution that shows who has the authority to bind this particular transaction. And more often than not, the title company will also ask for a statement of authority. A statement of authority is a statutory form that's used here in Colorado that shows who the parties that have the power to bind the entity are, what their powers and limitations are. So it keeps all the other private information off record. So oftentimes those people don't want all of their corporate documents put a public record. So that statement of authority will allow us to rely on that once we have reviewed their other corporate documentation.
Yeah, and real quick, Dean, when they're drafting their contracts and it's a corporation that owns, and this is corporations, not necessarily LLCs, but when it's a corporation that owns it, you know, they want to put that the owner is, or the buyer is the corporation, but then the signature lines at the bottom of your contract should say by the president. It should be the corporation by whoever is authorized to sign on that behalf. So the same documents that the title company is looking for, that's what you put in your contract to make it work.
Yep. And then we're of course going to want to know that the party that executed the contract, once we get the corporate documents, had the power to even sign the contract.
Yeah, and sometimes that's in that resolution, or they have to go back and ratify the contract with a resolution, but that goes back to the corporate resolution you were discussing.
That's correct. Oftentimes they'll just have a generic corporate resolution, and we want specific. Corporations can also give power of attorney. So if one of the corporate officers wants to delegate their power to another that's not an officer of the corporation, we're going to want to see that power of attorney to make sure, and the resolution, the corporate documents, to make sure that there aren't restrictions on who gets to delegate that authority on their behalf.
I imagine that's fairly rare.
Yeah, no, it happens. Unfortunately, it happens all the time.
Does it really?
Yes.
Oh, that's interesting.
And what we want to see is that the power of attorney is coming from the corporation and not coming from the individual who's giving the power. So if it is the president of the corporation that's giving the power, we want the power of attorney coming from the president of the corporation, the named corporation, not from them as an individual.
Yeah, so you can't have a power of attorney of a power of attorney. It's got to be now the corporation creates a power of attorney for the new person.
Yep, correct, for that fiduciary. Estates. We deal with, unfortunately, especially in this market, a lot of dead people. And once that person has passed, if it's not a joint tenancy situation, their estate has to be probated. So what we're going to be looking for are going to be the letters appointing that personal representative, or letters of administration. Oftentimes when we have letters of administration, it's where you have a professional fiduciary that is going to be acting as personal representative. When we're looking at just regular letters of appointment, oftentimes it's an individual, which oftentimes is an heir to the property, or somebody that's related to the family. But people don't want to be fiduciaries if they don't know what their duties are and what their obligations are. So oftentimes they will hire a professional fiduciary to be the personal representative of that estate, and then they will give letters of administration in that situation.
Real quick on the estates, you know, so the way that the contract should read for you guys on this is that if the seller is the estate, it should be the estate of Susie Smith is how it should read, and then the who signs on behalf is going to be, you know, the personal representative. That's who's going to be signing on the contract on their behalf. Dean, I'd like to talk real quick about, because we see this come up all the time. They get to closing, somebody died, it's the spouse that's selling the property. They get to closing, and then all of a sudden they realize it's in tenants in common. Can you give some quick, and I know this isn't what you're talking about with authorization, but could you give some quick advice for brokers when they're dealing with somebody that has passed away, how to make sure that they don't have to deal with that in the 11th hour, how to be more proactive?
Yep. So I always tell my realtors that if you're dealing with dead people, if you're dealing with the mention of bankruptcy or foreclosure, get that $5 O&E from your title insurance company. One, it's going to show you how the tenancy was held. And then when the seller tells you, well, my husband has passed, you're going to have a copy of the deed, the last vesting deed, which is going to show, did they hold title as joint tenancy, which has right of survivorship? Or is the deed blank to the tenancy, which automatically creates tenants in common? Or is it a tenancy in common estate with undivided interest in the property? If that's the situation, it's a non-joint tenancy situation, you don't have anybody to sign your contract on behalf of the estate's part yet. Until somebody's been appointed as their personal representative, the surviving spouse can bind their half of the property, but they don't have the power to bind the other person's interest in the property until the court has designated them as a personal representative. So just because they say, well, my husband has a will, says I'm the personal representative, that's one step, but you still have to have the court perfect that before you're going to have a valid contract on that property.
Hey, we had a great question come in, and think would be a good opportunity to address. So this person says, joint tenants. So is this a good way to leave property now to your son without giving him the whole title now? Sign a deed to both.
Yes, that's one way.
You're killing me. I'll tell you, I mean, it is one way to do it. Dean's absolutely right. I'll tell you, I get concerned about it because I see the worst of the worst. And what I've seen in cases is where, they decide, okay, what we're going to do is we're going to have husband, wife, and son, and we'll just do the deed to all of them in joint tenancy. That way, when husband and wife pass away, son ends up with the property. But I've seen instances where son, husband and wife now decide they want to move and they want to sell the property. And son says, I'm not sure I want to do that. And now you have to get all three approval before you can do it. The other thing I'll warn you against is that potentially tax consequences, in the fact that if you deed property to somebody else, then that could be considered gift, which may lead to potential gift tax. So you may want to talk to a tax accountant or somebody like that before you do it. I don't know what the implications are because I don't do tax, but I know that gifting something like that could have other repercussions too. The one that, and Dean, maybe would you mind just hitting on a beneficiaries deed a little bit about pluses and minuses with that? Because obviously it has some minuses too, but it does address the issue that I would be concerned about. Yeah.
So the issue that we had here in Colorado is with what we call desk drawer deeds. And that's where, grandpa's getting up in age and he wants to avoid probate. So what he wants to do is he's going to execute a deed today, conveying the property to the kids, stick it in a drawer or a safety deposit box, and tell the kids, when I pass, I want you to go get that deed and record it. And that way we can avoid probate. The problem that title insurance companies have is that we have a lack of what we call delivery of that deed. Put it in a desk drawer does not constitute delivery. Recording constitutes delivery. So if the deed is executed at the time of while they're still alive and then recorded, well, then that will pass good title to the property. But these desk drawer deeds do not. So they came up with the Beneficiaries Deed. And the Beneficiaries Deed is the deed that can be executed while the party is alive, recorded while they're alive, but does not pass title until they die. The problem with the Beneficiaries Deed is, yes, it can avoid probate, but there is a 4-month waiting period before the grantee can do anything with that property, because unrecorded creditors or parties that have unrecorded interest in that property have 4 months to record their documents from the time that the party has passed. So there is a 4-month waiting period before that the grantees on that Beneficiaries Deed can do anything with that property. So it may be able to avoid probate, but you've kind of stuck a wrench in the works by having to hold on to that property for 4 months. And oftentimes the kids don't want to hold on to the property for 4 months. They're ready to turn around and sell it.
And I'll tell you that the estate opening probate gets a bad name in Colorado from a lot of other states. And my understanding is that if you go to Florida or some of these other states, the estate attorneys will actually take a percentage of the estate as their legal fees. And that's why there's this big, we got to avoid probate. And Colorado typically doesn't have the same costs associated with the probate. So there's sometimes you may want to avoid probate if the only asset is the house. Sometimes it's not worth worrying about to avoid probate because the fees that you're saving may not be as much as you think they are. But talk that over with your attorneys. And Dean, I don't know what your experience has been, but that's been my experience with those estates. So
I absolutely agree.
So
another way. Yep.
Go ahead. I'm sorry.
Oh, I'm sorry. Go ahead, Damian.
I was just going to say, make sure you you know, avoiding probate does not have to be the end all be all. You know, you want to talk to your estate planning, you know, financial advisors or attorneys or something to find out what is the best vehicle. And a beneficiary's deed is not the worst thing in the world, as long as there's an expectation from your heirs that they understand they'd have to wait 4 months. But the benefit is at least if you want to sell your property, you don't have to ask your kids if it's okay. So, but you were going to say something else, Dean. My apologies.
Another way to accomplish this is doing a deed from the homeowner to the grantees, and then reserving a life estate interest in the property.
Oh, and now you're going to get really complicated, aren't you?
And the life estate interest is where the grantor is conveying the property to the grantees, but by reserving a life estate interest in the property allows them to live on the property until they die. Once they pass and we record their death certificate, then what we call the remainder men are now the vested owners of the property.
And of course, that also leads to the point that you can't sell the property, you can't realize the gain, you can't do anything with it because you've already vested it with your kids. So there is some deficiencies with that too. So talk to estate planners, have your clients talk to estate planners to figure out what you want to do with this. But, you know, just wanted to give you, Dean wants to make sure you understand how these things work when you're conveying the title, when you have these different issues.
Yep. General partnerships or partnerships. What we're looking for with a general partnership is that all partners have to execute the documents, unless there is documentation that allows a different scenario. We're looking for the certificate of partnership. Oftentimes it should be recorded with the clerk and recorder. More often than not, it's not. We're also looking for the partnership agreement and any amendments that shows who are the partners, what are their powers and limitations. And then we want that backed up with a statement of authority that we're going to record. And I'll give you just, and oftentimes title companies are going to ask for a statement of authority, no matter what kind of an entity it is, unless it's an individual. And I've got a sample of a statement of authority here. And this is pursuant to Colorado Revised Statute 383172. And it basically states the name of the entity that the statement of authority is being executed for, what the name of the entity is and what kind of entity it is, what's the mailing address, who are the parties that can bind the entity, what are their powers and limitations. More often than not, it's just limitations. And if it is a document that's used to perfect title in, let's say, for example, a trust that didn't do it right, and we'll go over the different ways to hold title in a trust, there is a space in the statement of authority that allows for the insertion of the recording information where the entity took title to the property. These need to be acknowledged by the proper parties, and then this is the document that gets recorded. The other documents, the resolutions, the partnership agreement, any of that other documentation, articles of organization, none of those get recorded by the title company. It's basically just the statement of authority once we have all the backup documentation. Guardianships. Well,
Hey,
I missed conservatorships.
No, I figured you did, but I figured you were going to do both of those together since they're kind of the same thing.
And I can do that.
Before you do that, I want to answer somebody's question they asked on the beneficiary deed, does it preclude a step-up basis? And the answer is, my understanding is no, it does not. But again, talk to your accountant to make sure. I'm not going to play an accountant, but I will tell you that I strongly suspect that you can still get your step-up basis. Sorry about that, Dean. But yeah, I figured conservatorships and guardianships kind of went together. So I figured you would do them at the same time.
There we go. So conservatorships are what we use when the party is either a minor. And Damian kind of touched on this a little bit when you want to add your kid to title. We had that happen and the kid was 13.
Oh God.
And, and now they show up the closing table and and all three of them show up and they want to sell the property. The job of the notary is to take identification and and make sure that these people are legally, have the legal capacity to execute the documents. A minor does not have the legal capacity to execute the documents. So the response we get is that, well, we're his or her guardian. We're her legal parents, we're her legal guardians. Guardians do not have the power to deal with real estate issues. The guardian's powers deal with personal issues, clothing, shelter, education, medical attention, food, things of that nature. Conservators deal with real property issues and banking issues. So that doesn't work for us. So now they've got to get a conservator appointed on behalf of the minor child. And we've also seen situations where, since it's a minor in child, they want a guardian ad litem appointed along with the personal representative, or along with the conservator. And the guardian ad litem may not feel that investing in real estate is a good investment for a minor. Investing at a trust account, an education account, those are what the guardian ad litem feels is good investments for the minor, not selling and buying real estate. So we've run into situations where the guardian ad litem will not allow the property to be sold out of the minor. And if the property is sold, the money goes into the minor's trust account. And the situation we had is they were outgrowing the house. They wanted to sell the house to move into a bigger house. And the court wouldn't allow the minor's part of the proceeds to be used to purchase another house.
Yeah, the moral of the story on that one is, for the love of God, do not put minor children on title to real estate. That's the moral of the story. But Dean, I've had this, conservatorship has come up a lot more, particularly in the world of COVID, because we've had people that got sick from COVID, ended up on ventilators, so they no longer were responsive in the middle of real estate transactions. So it's not an estate because they haven't died. Nobody did a power of attorney before they went into the hospital or before they ended up on a ventilator or anything else. And so literally it was a scramble to try and figure out if you could get a conservatorship for the buyer or the seller so they could complete a real estate transaction. So yeah, so this is not something that is something you guys do not see. This is something you will see, and it will require a court order and will require a attorney to help you file the paperwork.
Yeah. So not only as the title insurance company, not only are we looking for those letters of appointment, appointing the conservatorship, but we also need a specific court order allowing the sale of the property. As opposed to the personal representative in a deceased party's estate, if there are no restrictions, then they don't need a court order to sell the property out of the estate, only on the conservator side.
Yeah, more involved process.
Yeah, and more often, the pushback we get is that the letters don't say that there are any restrictions, but the statutes that deal with conservatorships state that a court order must back up the transaction. And then that's a scramble, especially now with COVID-19. You know, the banks, the courts are backed up, just like everybody else is backed up.
And you want to just touch on guardianship and how that relates as well with the conservatorship, Dean? Yeah.
So more often than not, the conservator and the guardian are more than likely the same party. But again, the guardian does not have the power to deal with real estate issues unless there is a specific court order allowing them to do that. And we have seen the court authorize a guardian to sell the real estate. It's not that common, but we have seen it.
And for conservatorships, guys, that's going to be still an estate. It's still an estate of somebody, even though it's not an estate of a dead person, it's an estate of a living person. So as far as your contract, it looks very similar in the fact that it would say, you know, the estate of Susie Smith. However, the signature would be by the conservator, not by a personal representative. That's the difference in as how that contract gets set up, or amend extend if you're signing for somebody that you just got a conservator appointed, you know, like amend extend or the closing documents would be by the conservator.
Yep. Individuals can hold title to real estate. Even minors can hold title to real estate.
Not a good idea.
Yeah, but minors can't do anything with it until they reach majority age, which is 18 here in Colorado. So with an individual executing, we just need a driver's license, you know, a valid government ID. And then it's going to be the job of the notary to make sure that the person appears to have the legal capacity to execute the documents. For the most part, notary publics are not doctors or nurses. And if they suffer from some kind of a mental illness or brain damage or dementia or any of the other mental incapacities, if they're not chasing around invisible flies, we're not going to know. If they're participating in the transaction, we're not going to look, we're not going to know. If the closer allows that party to execute the documents, the buyer's title insurance policy will cover them should that party not have the authority to do so. That's part of the policy coverage for the buyer.
And it also is, it's a high bar to show that somebody was, under duress or lacked capacity to, because I hear at times, well, I think the buyer was drunk when they showed up to closing or whatever, and that alone is not going to take them out of capacity. It's going to, I think, as you said, Dean, chasing invisible flies, or is that the analogy you use?
Yes. Yeah.
So,
or they're not paying attention.
Yeah. So it's got to be it's a fairly high bar to show those kind of things. And it is nice that the title companies have that provision to protect the buyer's interest if for some reason the seller later claims incapacity.
Yep. Of course, individuals can get power of attorney. So they'll get that a power of attorney in their individual capacity. Again, if they're going to do so, we want to look at their powers and limitations. Does it take effect upon disability? Is it not affected by disability? What is the age of the power of attorney? Those are all things that the title insurance company is going to take into consideration before we're willing to accept that power of attorney.
And one thing, if you're working from an old power of attorney or something that somebody's given you before, at the time of listing or even shortly after you go under contract or whatever, send it to the title company. Let Dean take a look at it and make sure that they're not going to run into some issue with that power of attorney. I mean, there's some strange power of attorneys out there. We've seen some from foreign countries. We've seen some from, that were executed by a notary that you don't know is a notary. I mean, it's something that Dean specializes in to be able to tell you. And the last thing you want to do is find out at the 11th hour that it's not okay because somebody thought it was. And Dean says, wait a minute, we got a problem here. This isn't lining up. Yeah. So.
Or we have the one that we run into a lot is you've got a power of attorney that doesn't take effect until the principal has been designated as incapacitated by 2 doctors. So now we got to get 2 doctors to sign off on their incapacity. And that could delay the process as well.
And they're in a foreign country when it happens.
Always.
And now we have to send them to the U.S. consulate to get a new power of attorney.
Yeah. So like I said, if you guys have one, make sure that you're talking to him ahead of time to find out what's going on and what you're going to need, because it might be easier just to execute a new one as opposed to dealing with the old one.
Yep, definitely, if they're able. One of the ones that we have most difficulty with is with these IRA accounts, where you've got the custodian or trustee of an IRA account that is named, and then the individual whose account it is also named. So you've got the custodian or trustee of the named IRA for the individual. And now we need to see who has the authority to bind that IRA account. And it's usually a group of individuals, usually their titles are trustees of the IRA account. So we want to again make sure that we have the right parties executing those documents. It's not going to be the individual; it's going to be the trustee for the IRA that's going to be executing the documents on their behalf. And oftentimes the individual thinks they can, since it's their account, they can execute those documents by themselves. And unfortunately, that is not the case.
And that goes for the contract too. I mean, when they're executing the contract on behalf of this IRA, you got to get that custodian to sign it, even though your client, who is the owner of the account, might think that they can sign the contract. It really needs to be that custodian. So,
yep.
With these agreements and everything else, they're going to be in place and you're anticipating this transaction. This is another one that would be good to talk to Dean or somebody about who's going to have authority, what are we going to need, so that you're making sure from the get-go in the contract that it's being set up properly. The seller or the buyer might be whatever the name of the IRA account is. And then the signature is going to be by that, by such and such as custodian or as trustee.
Yep. And it's usually a corporation. So we're going to need that corporate resolution that states who has the authority to bind again in that situation. And again, backed up with a statement of authority.
All sorts of documents in that one.
Yep. Joint ventures. I haven't seen a joint venture in quite some time. I don't know about you, Damian.
Most of the time they end up in limited liability companies because they have the flexibility to do a bunch of stuff in the operating agreement. So that's where I see these, what was once joint ventures ends up in the LLC. But go ahead and briefly talk about it, but I don't think a lot of people are going to see them.
No, I haven't seen one in years. So the authority is given to the president, vice president, secretary, or treasurer. So corporate officers have the power. We're looking for the certificate of joint venture that's being filed with the Secretary of State. And then we want to see the joint venture agreement and any amendments to see powers and limitations, and then backed up with the statement of authority that's recorded with the clerk and recorder. And again, the signature line is going to be the joint venture by, and then one of the officers, which is going to be one of the joint venturers. We see a lot of limited liability companies really popping up a lot now. We're looking for articles of organization filed with the Corporation Commission, Secretary of State. We're looking for the operating agreement. And oftentimes what they're sending us is articles of organization. The articles of organization only state who the agent is. It doesn't state who power is delegated to. That's the operating agreement. So we're going to need to see that one, that they have filed all their proper documentation with the proper entities, but that we also have the operating agreement backed up with statement of authority again. And again, the statement of authority is what we recorded with the clerk and recorder.
Do you need an operating agreement if it's sole member?
We see that it's a sole member a lot, but we just need to verify. We just need to do our due diligence that it's a sole proprietorship and that there isn't an operating agreement, because we see that a lot too.
Yeah, I think the statute says you don't need an operating agreement if it's a sole member LLC, but obviously that becomes hard for you to figure out how to verify that.
Yep.
So
and then it's even more difficult when that party's died. So now we have to get somebody appointed on behalf of them to act as the partner.
The personal representative who then appoints a partner. Oh, fun.
So it gets layered.
Yeah. Does the statement of authority deal with who's the sole proprietor? They do a statement of authority for this as well, I assume.
Yes, they do. Yes, they do. Limited liability partnerships, as opposed to limited liability companies or corporations. Again, this is a partnership. So we're looking, the party that has the power is going to be the general partner. We are again looking for the partnership agreement, and that's going to state who has the power, what are their limitations, and then we want that backed up with a statement of authority that we record. Real estate investment trusts. Don't see those a lot in residential transactions, but we do see them. It is going to be the corporate officer for that real estate investment trust that has the power to bind that entity. We want to see the articles of incorporation, a certificate of good standing filed with the Secretary of State. And then we want to see the bylaws and a corporate resolution that shows who has the power to bind the entity. And then we want to record a statement of authority again to back that up. Receiverships, don't see many of those. Oftentimes when we see a receivership, it's in a bankruptcy situation where the bankruptcy trustee has been appointed as receiver for the entity that holds title to the assets.
Why don't you, Dean, would you just back up and kind of explain what a receivership is? Because I'm sure there's a lot of people that may not even know how that works, as far as why you would even have a receivership.
Oftentimes you have a receivership because either the creditors are fighting or the entity is fighting amongst themselves as to who has the power to deal with this entity.
Or the bank is foreclosure and the bank is foreclosed on the entity or the seller, and they want to make sure that the assets are protected of the entity. It's a mechanism, guys, we want a third party keeping our money so that somebody else isn't stealing it is essentially, I mean, am I oversimplifying, Dean?
Nope, that's it. And again, that's done through the court system. Okay, just like letters of appointment are, that receivership is created through through a court order. Trust.
And it's very similar to like conservatorship or guardianship or estate and all that other stuff, just so you guys know what it is. And you won't see it much unless you end up dealing with somebody either in bankruptcy or that's the lender's foreclosing. You might end up with the receiver if they're, talking to them before they end up finishing the foreclosure process. Those are the different places you'll see them, but it doesn't come up very much in the sale of property.
Or you're seeing a sale out of the bank that has done the foreclosure, and they're appointing a receiver on behalf of the bank to sell the property. Trusts.
Do you want to do unincorporated associations first before you get into trusts, since I know that they're a little more complicated?
Yeah, absolutely. So unincorporated associations, oftentimes when we're dealing with unincorporated associations, it's churches. And with the church, again, it's going to more likely, it's going to be they're set up like a corporation. So it's going to be the president or drawing a blank here. One of the secretary, vice president, treasurer, and officer of the corporation, which we're looking to bind the entity. We're going to be looking at the bylaws of the corporation again to see what their powers and limitations are. We absolutely need a resolution from the board of directors in these situations, especially when we're dealing with church, where they're going to appoint somebody that's going to sell the church property. We need a corporate resolution to do that, and then backed up with the statement of authority. And then last but not least, trusts. And these are the ones that we have the most issues with.
This is fun.
Yeah. Trust. With a trust, you've got a trustee that's been appointed, either, and typically it's through the trust agreement itself. And then what we're looking for is a statement of authority that's recorded and the trust agreement and any amendments. There are several ways to hold title in a trust. And unfortunately, they not all work for us here in Colorado. There was a Senate bill that was passed back in 2001 that corrects the problems that we had in the previous statute, which was under CRS 383108, which allowed title to be held in a trust as long as it was backed with a statement of authority. The problem that we were having is there are several ways, and a trust may acquire, convey, encumber, or lease, or otherwise deal with any interest in real or personal property in the name of the trust, but must be backed up with a statement of authority. There are several ways to create a trust. The best way for title insurance companies is to vest title in the name of the trust. You just deed the property over to the trust, then back it up with a statement of authority, which will name the trustees, their powers and limitations, and we're off and running. If there is a change in the trustees, then we need a new statement of authority recorded, but then we also want to review the statement, the trust agreement, to make sure that the parties that have been appointed as successor trustees were actually appointed as successor trustees, and they're just not calling themselves successor trustees. So that's one way to hold title in a trust, is in the name of the trust, back it up with a statement of authority. Another way to hold title in a trust is by deeding the property into the trustees, name the trust, the date of creation of the trust, and all the named beneficiaries. Has to have all four parts. And people don't want to name the beneficiaries. Oftentimes they don't even want to name the trustees. So in that situation, if one of the four is missing, in order for you to perfect title in the trust, it has to be backed up with a statement of authority. So you can deed the property to the trustee of the named trust as long as it's backed up with a statement of authority. If you just deed the property to the trustee of the named trust with the date, leave off the beneficiaries, the trustee holds title as an individual with some fancy verbiage after their name. It's got to be backed up with a statement of authority. And we see these most often coming out of the Sunshine States like California, Arizona, and Florida, where it just doesn't work here in Colorado. You have to name all four parts or deed it into the trust and record the statement of authority.
And a lot of people do the trust because they're scared of probate. They think that putting something in a trust somehow makes it better for the beneficiaries later on. And there's reasons for doing trust, but a lot of them coming out of Florida and California and Arizona is because of different reasons that they're trying to avoid probate. Mm-hmm. And if you're doing your contract, then you would put the ABC trust is obviously who your buyer or your seller is. And then the signature is going to be by the trustee, assuming that that's who has the authority to sign on behalf of the trust. And if there's multiples, then you'd have two signature lines by co-trustees. Just like with personal representatives, it would be co-personal representatives if there's two of those as well. So
yep.
Again, helpful to talk to Dean and figure out how the authority works to make sure you're working with the proper people when you do those contracts so that you know the contract is going to match up when you're trying to do the deed later at the closing.
Yep. So in Colorado, if title is vested in the trustees, and there's more than one trustee, and one of those trustees passes, Colorado law recognizes the two trustees to hold title as joint tenants on behalf of the trust, so that when one passes, the power automatically transfers to the survivor. Because the trust document doesn't say Joe and Mary as co-trustees as joint tenants. It just says as co-trustees. But in Colorado, co-trustees are seen to be taking title as joint tenants on behalf of the trust. I hope that makes sense.
Yeah, we got some questions. Actually, let you finish. So there's a question on the trust that says, is the certificate of trust versus the declaration acceptable?
As long as it has all the necessary information on it, a certificate of trust it will work as well. And so here is statement of authority. And
then we have a couple questions on the statement of authority too, but I'll let you finish up with your
Perfect.
trust affidavit and everything else, and then we'll get into those.
So here's the trust affidavit that was in place under the old statute, which dealt strictly with trusts. The one that's taken its place deals with any entity, joint ventures, trusts, partnerships, corporations, any entity. But basically the trust affidavit stated what the name of the trust was, who are the trustees and their addresses, who are the beneficiaries under the trust, which people don't want to disclose more often than not, who has the power to bind the trust, and then it is signed, executed, and recorded with the clerk recorder. So this was the old form before they changed that, before they passed that new Senate bill back in 2001. The new form is a statement of authority, and the statement of authority again deals with any entity. So up at the top, it recites the statute that it's being executed under. It names the entity, in this situation, the ABC Trust, and then it says what kind of an entity it is. Is it a trust? Is it a corporation? Is it a partnership? Is it an LLC? Is it a LLP? Is it a joint venture? What kind of entity is it? What's the mailing address? Where was it formed? Who are the parties that have the power to bind the entity? What are their limitations? Typically, once they've been appointed as a trustee, then they have the powers to deal with real property issues under the statutes. And then if they didn't perfect the transfer into the trust because they only put one or two of the parts that need to be included to become a trust: the trustee, name of the trust, date of the trust, names of the beneficiaries, not supported by a statement of authority, then they can execute the statement of authority after the fact, refer to the document that they're trying to perfect. And once that document has been recorded, then any tax liens or judgments against the trustee won't attach to the real estate. Because until they record that statement of authority and don't have all the right parts to it, the trustee holds title as an individual with some fancy verbiage after their name. And any general index items like tax liens and judgments could attach to that individual trustee. Once that statement of authority has been recorded, then it can't attach to the trustee, if that makes sense. So we always want to perfect those entities because the state of Colorado recognizes them as holding title as an individual if they don't have all the necessary parts in the deed.
Jill, you want to ask him some of those questions before he goes through the trust, just about the statement of authority, since he was talking about that? And
Yeah, there was a comment here, a concern that when the statement of authority is recorded, there goes the privacy aspect. What are the concerns with regards to statement of authority getting recorded?
That's true. That's absolutely true. And that's why we have those privacy protection statute that is in place. And oftentimes if people want to protect their identity, they won't name themselves as trustee. If you're that passionate about keeping your identity safe, you're probably going to appoint your accountant or your attorney as your trustee. So that's one way to avoid that scenario. But there's no avoiding getting the names of the trustees put of public record, unless they get them redacted through the privacy statute that we have here in Colorado.
There was another comment here. I just had a deal close with a corporation out of Florida. When I requested the statement of authority, he told me he's never been asked for that document ever.
That's true.
That is true.
That is true. that can be absolutely true when it comes to corporations.
Or anybody else. Aren't we unique on statement of authority?
Yeah, we are. We are. So yeah, that's a Colorado statute. The statement of authority is a Colorado statute. I don't know if any of the states have that. But
I would say the Florida lawyer should probably bone up on his Colorado law before making statements. But what do I know?
but that is very true. With a corporation, we can live with that corporate resolution, as opposed to having to record a statement of authority. So typically, that's the only one that we will not have to have a statement of authority. It's going to be a corporation, but we have to have other documentation to back it up, which is going to be that corporate resolution. So I would imagine that you're going to have lots of lawyers that say, I've never been asked to have that. And that's because it's unique to Colorado. I have also included a list of all the different kinds of trusts, and it's my understanding that Jill will be handing this handout to everybody that was attending this class today. But basically, trusts are set up to oftentimes to protect the identity of the party that's holding title to the process, to the property, or to shield them from probate should somebody pass. The ones that we deal with most often are going to be irrevocable trusts. And irrevocable trust is a trust which cannot be changed or canceled once it is set up without the consent of the beneficiaries. Contributions cannot be taken out of the trust by the grantor. Irrevocable trusts offer tax advantages that revocable trusts do not. For example, by enabling a person to give money and assets away even before he or she dies, which is the opposite of a revocable trust. So any kind of trust, we're going to need that statement of authority. We're going to need to see the trust agreement as well for powers and limitations. Land trusts, we are going to start seeing a lot of community land trusts here in Colorado now that are starting to create more affordable housing communities, where you're going to have a community land trust that holds title to the land. The party who's buying is going to own the improvement and typically get a 99-year lease on the land. We have a problem with the Green Valley Ranch subdivisions that are out by DIA that are part of the affordable housing program. And the affordable housing restrictions are buried somewhere in a covenant or in the first deed out of the developer, and then it gets lost in the trail.
Yeah, there was a big old article on this several years ago where there was also after the Great Recession, and people were, I mean, you guys, the poor title companies got hammered when frankly, it wasn't even their fault, but
Yep.
yeah.
Yep. So in order to combat that, what they're going to do is it has to go through the community land trust has to give the lease, and then you purchase the improvement. So there's going to be two documents, a lease and a deed.
Which probably makes more sense because at least then there's a trail that is easier for the title companies to track.
Denver is the only one that has this problem. Other counties in the state of Colorado, oftentimes what they'll do is they will record a one-page mortgage after the purchase money mortgage, and there is no dollar amount. It's comply with the affordable housing program. And it's a recorded document that no title company is going to miss, even on an O&E. That's going to show up on an O&E. And that way we're going to catch it every time. We know it's an affordable housing situation, and it's going to get caught every time, as opposed to burying it in some covenant or burying it in the first deed out of that developer, which has caused the city and county of Denver many, many headaches and many letters to buyers that didn't qualify.
Yeah, saying, please sell the property. Sorry, you paid too much for it.
Yep, but you have to sell it at a loss.
Yeah, the pot trust is not what everybody in Colorado thinks it is.
No, it isn't. One thing that title insurance companies will have a big problem with is pure trust. Oops, let me get back up here. The pure trust is a scheme in which people are convinced to place all their assets into a number of trusts of dubious legitimacy in order to hide their assets from creditors and tax collectors. There are 4 vulnerable communities that are the victims of these cons or frauds: the elderly, recent immigrants, the devoutly religious, and the so-called patriot community. And we see them most with the patriot community, which is the sovereign citizenship movement that we're seeing. And we title insurance companies don't feel that these are a valid trust that are being created under these trust agreements, under these pure trusts. So if you have title that's being vested in a pure trust, you're going to want to probably have to shop around for a title insurance company that's willing to insure your transaction.
Dean, there was a question from somebody about where would a heritage trust fall?
I'm not familiar with that term.
I'm assuming that's probably one that is like a testamentary trust. Wouldn't that be? I'm not familiar with the term either,
that's
but
very possible.
I'm thinking they're thinking a testamentary trust.
Yeah, and I'll go over that. So a revocable trust. So the ones that we deal with mostly are going to be irrevocable and revocable trusts. Is the ones that we deal with most often. The revocable trust is a trust that can be changed or canceled by its grantor or by any other person, does not avoid estate taxes as an irrevocable trust does. So again, with these trusts, we need to see a trust agreement. Statement of authority needs to be recorded to back it up. A testamentary trust is a trust that's created in that party's will. So it's not a separate trust agreement that's created. The trust is created in their will. And so now we have to review the probated will to verify that the trust is been created in the will. And then again, who are the named trustees of that trust?
And a testamentary trust is typically obviously irrevocable too, once it's created.
Yes, that's correct. That is correct. And for the most part, I am done, unless people have any questions.
We'll give everybody a minute to put their questions in chat. But right now we're caught up on those questions. Dean, that was terrific.
Awesome. And
Lots
again,
of information.
Yes.
That was a lot of stuff in an hour there, Dean.
Yep. And again, hopefully the PowerPoint presentation that was done, put up here, will be helpful for you when you receive it. as a reminder.
All right.
Looks
Okay,
like we
well,
did it, honey. Looks like Dean,
yeah,
Dean doesn't
sounds
have questions
great.
like I do. Apparently he does a much better job. So
Yeah, he covered it
I
all.
doubt that.
If after today, you guys, you have any questions that pop up, feel free to shoot me an email. We're more than happy to be a resource and answer any of your questions that come up. And, as always, if you've got a listing coming up and you'd like to give Heritage an opportunity, we would love to be your title company. Reach out to me and I'll be happy to connect you with a great closer. Thanks so much again for spending the afternoon with us. We really hope you got a lot out of today. Dean, thanks again.
Thank you.
You're the man. Damian, as always.
Thank you, Damian.
Appreciate you guys. So have a wonderful rest of your week and we'll look forward to seeing you on next month's industry update. Thanks again for joining.
Thank you.